Part 1 of the Public Procurement and Asset Disposal Act of Kenya, Cap 412C, lays out the basic framework for how the Act functions. It establishes the name of the Act, the definitions of key terms, and the basic principles that should be used in public procurement and asset disposal. It also addresses conflicts between the Act and other legislation. Section 1, titled Short Title, simply states that the Act can be referred to as the Public Procurement and Asset Disposal Act. Section 2, titled Interpretation, provides definitions for various terms used in the Act. This includes terms like accounting officer, assets, public procurement, procuring entity, tender, and many others. These definitions are important for understanding the specific meanings of these terms within the context of the Act. Section 3, titled Guiding Principles, lays out the values and principles that should guide public procurement and asset disposal. These principles are derived from the Constitution of Kenya and other relevant laws. The principles include accountability, transparency, fairness, competition, and value for money. Section 4, titled Application of the Act, clarifies what types of procurement and asset disposal the Act applies to. For example, the Act applies to procurement planning, procurement processing, inventory and asset management, disposal of assets, contract management. This section also identifies activities that the Act does not apply to. For example, the Act does not apply to retaining individuals as employees or to asset transfers between state organs or public entities without financial consideration. Section 5, Conflicts with Other Acts, addresses what happens if there is a conflict between this Act and other legislation. This section clarifies that the Public Procurement and Asset Disposal Act will prevail over other laws or government notices in matters related to procurement and asset disposal. The exception to this is if an Act of Parliament specifically governs the procurement of particular professional services. Finally, Section 6, Conflict with International Agreements, sets out the procedure for handling situations where the Act's provisions clash with Kenya's obligations under ratified treaties or international agreements. This section clarifies that in such cases, the terms of the treaty or agreement will take precedence. It further outlines requirements to ensure that even in procurement activities under international agreements, Kenyan interests are considered. These include sourcing goods and services locally wherever possible and using Kenyan insurance and transportation companies. Overall, Part 1 of this Act establishes the fundamental framework for public procurement and asset disposal in Kenya. It sets the ground rules, defines key terms, outlines guiding principles, and establishes procedures for handling situations where this Act might conflict with other legislation or international agreements. Part 2. The bodies that regulate public procurement and asset disposal in Kenya. Part 2 of the Public Procurement and Asset Disposal Act outlines the roles and responsibilities of the different bodies involved in regulating public procurement and asset disposal in Kenya. It focuses on three key entities: the National Treasury, the Public Procurement Regulatory Authority, the Authority, and the Public Procurement Administrative Review Board, the Review Board. A. The National Treasury's role. The National Treasury plays a crucial role in setting the overall policy framework for public procurement and asset disposal. Its responsibilities include developing policies and guidelines for procurement and asset disposal by public entities, creating an efficient procurement management system for both national and county governments, providing technical assistance to public entities on procurement matters, developing policies on affirmative action and the participation of disadvantaged groups in procurement, developing and reviewing policies on asset management, issuing guidelines on procurement to public entities. B. The Public Procurement Regulatory Authority. The Public Procurement and Asset Disposal Act establishes the Public Procurement Regulatory Authority as a body corporate with perpetual succession. This means it can sue and be sued, acquire and dispose of property, and perform any other actions needed to fulfill its functions. To ensure accessibility, the authority can also set up offices in different regions of Kenya. The authority's primary functions include monitoring, reviewing, and assessing the public procurement and asset disposal system to ensure it aligns with the Constitution, particularly Article 227, and recommending improvements. Monitoring the public procurement system, reporting on its functionality, and suggesting improvements to the Cabinet Secretary and County Executive members for finance. Developing and implementing a comprehensive training program for public procurement officers. Registering, regulating, and overseeing procuring agents and asset disposal agents. Developing and maintaining a central database of registered suppliers, contractors, and consultants. Investigating complaints related to procurement and asset disposal proceedings that are not under administrative review. Researching public procurement and asset disposal trends and developments. Advising the Cabinet Secretary on setting standards, including international standards for public procurement and asset disposal. Publishing information related to procurement, including statistics, price comparisons, details of non-compliant entities, and other relevant information for the public. Informing relevant authorities, including the Cabinet Secretary, Parliament, and the Auditor General, about non-compliance with procurement laws, particularly if the concerned entity ignores the authority's directives. Submitting annual reports to Parliament and county assemblies. Developing a code of ethics for procuring entities and winning bidders involved in public procurement and disposal. Collaborating with state and non-state actors to gather recommendations for improving public procurement and disposal. Ensuring procurement entities implement preference and reservation schemes and provide data to the authority, broken down to show the benefits received by disadvantaged groups. Developing, promoting, and supporting training and capacity development for people involved in procurement and asset disposal. Performing other functions stipulated in the Act and other relevant laws. The Act also grants the authority the power to initiate civil or criminal proceedings against state organs, public entities, or officials if, during monitoring, it finds evidence warranting such action. See the Public Procurement Administrative Review Board. The Public Procurement Administrative Review Board serves as an independent body for handling appeals related to procurement decisions. It is established as an unincorporated board, meaning it doesn't have a separate legal identity from its members. To ensure accessibility, the review board must provide reasonable access to its services across Kenya. Key aspects of the review board. Functions and powers. The review board hears and determines requests for review, issues binding decisions, dismisses frivolous requests, and can impose costs on parties involved. Composition. It consists of 15 members appointed by the Cabinet Secretary, ensuring regional and gender balance. These include a chairperson with the qualifications of a High Court judge, 7 members with qualifications specified in regulations, and 7 other members appointed by the Cabinet Secretary. The Act also mandates the inclusion of professionals nominated by various bodies like the Law Society of Kenya, the Institute of Certified Public Accountants of Kenya, and the Architectural Association of Kenya, ensuring representation from different fields. Qualifications. Members need a university degree, at least 7 years of experience in their field, then must meet Chapter 6 of the Constitution's requirements on leadership and integrity. They serve on a part-time basis. In essence, Part 2 of the Public Procurement and Asset Disposal Act sets the stage for how public procurement and asset disposal are regulated in Kenya. It designates responsibilities to the National Treasury for setting policy, empowers the authority to oversee and enforce the system, and establishes the review board to adjudicate appeals and ensure fairness in the process. Part 3. Decentralizing procurement. The county government's role. Part 3 of the Public Procurement and Asset Disposal Act focuses on the responsibilities of county governments in managing procurement and asset disposal within their jurisdictions. While the National Treasury sets the overall policy framework, as described in Part 2, the county governments have operational control over procurement within their respective counties. The County Treasury is the main body responsible for implementing public procurement and asset disposal policies at the county level. It's tasked with establishing a procurement function staffed with qualified professionals. This function plays a critical role in advising the accounting officer, preparing procurement plans, and ensuring compliance with the Act and its regulations. To streamline procurement processes, the County Treasury is also authorized to set up an institutional framework for procuring, administering, and managing common user items. Common user items refer to goods and services commonly used across different county government departments, such as office equipment, furniture, vehicles, and stationery. By centralizing the procurement of these items, county governments can potentially achieve cost savings through economies of scale. Part 4. Enforcement. Ensuring compliance with procurement laws in Kenya. Part 4 of the Public Procurement and Asset Disposal Act focuses on the powers and mechanisms for ensuring compliance with the Act's provisions. While previous parts establish the framework and assign roles to different entities, Part 4 outlines the tools available for enforcing compliance. Information gathering and investigation. The Act mandates that all public entities must furnish the National Treasury or the Public Procurement Regulatory Authority, the authority, with any information related to procurement and asset disposal that these bodies request in writing. This provision ensures transparency and accountability by enabling oversight bodies to access relevant information. The authority is granted broad investigative powers. It can conduct investigations into a procuring entities and its contractors, suppliers, or consultants' records and accounts. These investigations are aimed at uncovering any breaches of the Act or its regulations. Corrective measures and orders. Based on the findings of an investigation, the Director General of the authority is empowered to take corrective actions, including directing the procuring entity to rectify the identified violation, terminating the procurement or asset disposal process altogether, submitting a report summarizing the investigation's findings and recommendations to relevant authorities for further action, requiring the procuring entity to transfer the procurement responsibilities to another entity. Before taking any of these actions, the Director General must provide an opportunity for the procuring entity and any other parties potentially affected by the order to present their case. Judicial review and debarment. The Act provides for checks and balances to ensure fairness. The procuring entity or any party entitled to make representations can seek judicial review of the Director General's order in the High Court. This provision prevents the authority from acting arbitrarily and ensures that its decisions can be challenged in court. Debarment, a significant penalty, is also addressed in Part 4. The Public Procurement Regulatory Board, which manages the authority, can debar a person or entity from participating in future procurement or asset disposal proceedings for reasons including conviction for offenses under this Act or other laws related to procurement, breaching a procurement contract with a public entity, providing false information about qualifications, refusing to enter into a written contract, breaching the authority's code of ethics or professional codes of conduct, tax defaults, corrupt or fraudulent practices, and serious violations of fair employment laws, filing frivolous or vexatious requests for review. Debarment decisions are subject to judicial review, allowing affected parties to challenge the board's decision in the High Court. Inspections and entry. Part 4 grants authorized personnel the power to enter premises and access information for inspection, assessment, and review purposes. If entry is refused, the authority can apply for a warrant from a magistrate authorizing police to enter the premises. In summary, Part 4 focuses on empowering the authority and other relevant bodies to enforce the Act's provisions and ensuring that public procurement and asset disposal processes in Kenya are conducted fairly, transparently, and in accordance with the law. Part 5. Organizing for procurement. The internal structure of procuring entities in Kenya. Part 5 of the Public Procurement and Asset Disposal Act outlines the internal organizational structure and responsibilities of procuring entities in Kenya. It focuses on establishing clear roles and processes within these entities to ensure compliance with the Act's principles of transparency, accountability, and fairness. The Accounting Officer's responsibilities. The Act designates the accounting officer of a procuring entity as the person ultimately responsible for procurement and asset disposal activities. The accounting officer must establish systems and procedures. This includes creating a structured decision-making process for procurement and asset disposal consistent with the Act and its regulations. Oversee procurement planning. The accounting officer must ensure the development of annual procurement plans that align with the entity's budget and comply with the prescribed threshold metrics. They also must submit a section of this plan to the authority demonstrating how preference and reservation schemes will be applied. Ensure proper documentation and record keeping. All procurement proceedings must be thoroughly documented and records securely stored, as mandated by the Act. Approve and sign contracts. The accounting officer has the authority to approve and sign all contracts entered into by the procuring entity. Ensure segregation of duties. Procurement processes must be handled by different individuals or departments responsible for initiation, processing, and receipt of goods, works, and services to prevent conflicts of interest and potential abuse. Seek assistance when needed. If a procuring entity lacks the capacity to comply with the Act, the accounting officer must seek assistance from the National Treasury. Comply with specific provisions. The Act outlines additional responsibilities for accounting officers, including adherence to relevant sections of the Public Finance Management Act and compliance with Article 71 of the Constitution when procurement involves natural resources exploitation. Committees and functions. The Act emphasizes a structured approach to procurement and disposal by requiring the formation of specific committees. Evaluation Committee. This committee plays a critical role in the technical and financial assessment of procurement processes. The Act details its composition, specifying a mix of internal staff with relevant expertise and potentially external consultants or professionals for specialized procurements. The committee's responsibilities include bid evaluation, proposal assessments, pre-qualification reviews, and negotiation of procurement terms. Its secretary is typically the head of the procurement function or a designated officer from that function. Inspection and Acceptance Committee. This committee verifies the quality and quantity of goods, works, or services received by the procuring entity, ensuring they conform to the contract specifications. It plays a vital role in preventing the acceptance of substandard deliverables. Procurement function. The Act emphasizes the importance of a dedicated procurement function within procuring entities. This function must be staffed by qualified procurement professionals with recognized qualifications in Kenya. The head of the procurement function provides professional advice to the accounting officer on all procurement matters. Disposal Committee. Responsible for overseeing the disposal of assets. The committee evaluates disposal recommendations, conducts surveys, and suggests the best disposal method to the accounting officer. Specialized procurement and disposal arrangements. The Act allows for flexible procurement arrangements to meet the specific needs of different entities and situations. Sector-specific agencies. Procuring entities with shared interests, often within a particular sector, can establish joint procurement agencies to handle the procurement and distribution of goods, works, and services. This fosters collaboration and allows entities to benefit from economies of scale. Consortium buying. Similar to sector-specific agencies, consortium buying allows procuring entities with common needs to pool their resources and procure goods or services jointly, leveraging their combined purchasing power for better prices and terms. Procuring agents. In cases where a procuring entity lacks the internal capacity or expertise to manage procurement effectively, it can appoint a procuring agent to carry out specific procurement activities on its behalf. The Act sets conditions for appointing agents, requiring the procuring entity to demonstrate a lack of internal capacity or justify the need for external assistance. It also mandates that agents must be registered and licensed by the authority, ensuring they meet the required standards and qualifications. Transfer of procurement responsibility. The Act allows for the transfer of procurement responsibility to another public entity or a procuring agent, subject to certain conditions and approvals. Overall, Part 5 of the Public Procurement and Asset Disposal Act aims to establish a robust and transparent internal framework for managing procurement and asset disposal within procuring entities. By defining roles, responsibilities, and procedures, the Act seeks to prevent corruption, ensure efficient use of public resources, and promote fairness and competition in procurement processes. Part 6. Fair play. General Principles for Procurement and Asset Disposal in Kenya. Part 6 of the Public Procurement and Asset Disposal Act outlines the general principles governing procurement and asset disposal in Kenya. These principles underpin the entire procurement process and are designed to ensure fairness, transparency, and value for money. Planning and pricing. Mandatory planning. Before initiating any procurement, the accounting officer of a procuring entity must prepare a comprehensive annual procurement plan that aligns with the approved budget and adheres to the Act's regulations. The plan outlines the procurement needs, including the goods, works, or services required, the estimated costs, and the preferred procurement methods. This plan must include specific choices for procurement methods and percentages reserved for different categories like women, youth, or persons with disabilities. The plan also serves as a public invitation to treat, which means it allows potential suppliers to express their interest in providing the goods or services listed. No splitting contracts. Procuring entities are prohibited from artificially splitting contracts into smaller parts to circumvent the prescribed procurement procedures. This provision prevents the manipulation of the system to avoid open and competitive bidding. Eligibility and fairness. Eligibility criteria. The Act sets out specific criteria that a person or entity must meet to bid for a contract. These include legal capacity to enter into a contract, not being insolvent, bankrupt, or in the process of winding up, meeting all professional requirements if the bid involves a regulated profession, not being debarred from participating in procurement proceedings, having fulfilled tax obligations, not being convicted of corrupt or fraudulent practices, not being guilty of serious violations of fair employment laws. Declaration of interest. If a person or entity with a substantial or controlling interest in a bidding company has a conflict of interest, they must declare that interest in writing. Standard documents. The Act mandates the use of standard procurement and asset disposal documents issued by the Public Procurement Regulatory Authority, the authority. This uniformity ensures consistency and transparency across all procurement processes. Preventing conflicts of interest. Restrictions on state and public officers. The Act specifically prohibits state and public officers from participating in procurement processes where they have a conflict of interest. This includes awarding contracts to themselves, their relatives, or business associates. They must also recuse themselves from decisions related to procurement if they have a personal interest in the matter. Technical requirements and tender security. Specificity of requirements. Procuring entities must provide clear and complete descriptions of the goods, works, or services being procured to ensure fair and open competition. These requirements should avoid mentioning specific brands or suppliers unless absolutely necessary. Tender security. Procuring entities may require tender security to be submitted with bids. This security acts as a guarantee that the bidder will honor their bid if it is accepted. The form and amount of this security are prescribed in the regulations. Key principles of the procurement process. Electronic procurement. The Act encourages the use of electronic means for various stages of the procurement process, including publishing notices, submitting bids, opening tenders, evaluating bids, requesting information, disseminating laws and regulations, and using digital signatures. This promotes efficiency and transparency. No undue influence. After the deadline for submitting bids, bidders are prohibited from communicating with the procuring entity in any way that could influence the evaluation process. This prevents attempts to sway the decision in their favor. Prohibition on corrupt practices. The Act expressly prohibits any corrupt, coercive, obstructive, collusive, or fraudulent practices in procurement and asset disposal proceedings. Violations can lead to disqualification from the bidding process, voiding of contracts, and even criminal prosecution. Mandatory disclosure of conflicts of interest. The Act mandates that any employee, agent, or board member of a procuring entity who has a conflict of interest with respect to a procurement must disclose that conflict in writing. They are also prohibited from participating in the procurement proceedings or decisions related to the contract. Confidentiality and record keeping. Confidentiality. The Act outlines strict confidentiality requirements to protect sensitive information during and after procurement proceedings. This includes information that could impede law enforcement, harm commercial interests, or compromise fair competition. Procurement records. The Act requires procuring entities to maintain detailed records of all procurement activities for at least 6 years after the completion of the contract. These records must be made available to bidders and interested members of the public upon request. Written approvals. All approvals related to procurement procedures must be given in writing and documented properly. This ensures accountability and a clear audit trail. In summary, Part 6 of the Act establishes the core principles of fair play that guide all procurement and asset disposal activities in Kenya. It aims to create a level playing field for all participants, safeguard public resources, and promote ethical conduct throughout the procurement process. By adhering to these principles, procuring entities contribute to a more transparent, accountable, and efficient public procurement system. Part 7. The nuts and bolts. Basic procurement rules in Kenya. Part 7 of the Public Procurement and Asset Disposal Act outlines the fundamental rules governing procurement procedures in Kenya. These rules are designed to operationalize the general principles outlined in Part 6 and ensure a standardized and transparent approach to procurement. Standard tender documents and registration of suppliers. The Act mandates using standard tender documents developed and issued by the authority. These documents ensure uniformity and clarity in procurement processes across all procuring entities. Procuring entities must maintain updated lists of registered suppliers categorized by goods, works, or services. This list serves as a pool of potential bidders for future procurement needs. Procurement process. A step-by-step guide. 1. Initiation. The procurement process begins with a formal initiation based on the pre-approved annual procurement plan. 2. Invitation to tender. A detailed invitation to tender is prepared, outlining key information such as procuring entity's name and address, tender number, description of goods, works, or services, instructions for obtaining tender documents, submission deadlines and opening details, applicable preferences and reservations, eligibility criteria, requirement for page serialization in bids. 3. Modification of tender documents. Tender documents can be modified or withdrawn before the submission deadline, but not after. This ensures that all bidders have access to the same information. 4. Submission and receipt of tenders. Tenders must be submitted in writing, signed, and sealed, if submitted manually. A dedicated tender box is used to receive bids, ensuring security and preventing tampering. 5. Opening of tenders. A tender opening committee, comprising at least 3 members, is appointed to publicly open the tenders. The committee reads out key details of each bid, including name of the bidder, total price, including modifications and discounts, tender security details. 6. Tender evaluation. The evaluation committee, appointed by the accounting officer, evaluates and compares the responsive tenders based on the criteria outlined in the tender documents. The evaluation process considers compliance with technical specifications, pricing and value for money, bidder qualifications and experience, adherence to legal and ethical requirements. 7. Clarifications. The procuring entity can request clarifications from bidders to ensure a thorough understanding of their proposals. However, these clarifications cannot change the original terms of the bid. 8. Correction or revision of tenders. The Act specifically prohibits any correction, revision, adjustment, or amendment of the submitted tender price after the tender opening. This maintains the integrity of the bidding process. 9. Post-qualification. For complex or specialized procurements, a post-qualification process may be conducted to assess the capabilities and resources of the shortlisted bidders. 10. Contract award recommendation. Based on the evaluation results, the evaluation committee recommends the most suitable bidder for the contract award to the accounting officer. This structured approach ensures a transparent, accountable, and fair procurement process that aligns with the principles of efficiency, fairness, and value for money. It minimizes the risks of corruption and promotes healthy competition among potential suppliers. Part 8. Special handling. Classified procurements and disposals. Part 8 of the Public Procurement and Asset Disposal Act addresses the unique considerations involved in procurements related to national security and classified information. It recognizes that while transparency and open competition are essential principles, they must be balanced with the need to protect sensitive information that could compromise national security. Dual list system for classified procurement. The Act introduces a dual list system for managing classified procurements. This system involves 1. Public list. This list, accessible to the public, contains general information about procurement needs and awards, similar to other procurements. 2. Classified list. This confidential list, maintained by the procuring entity, details specific items and suppliers related to national security. Access to this list is restricted to authorized personnel to safeguard sensitive information. Procuring entities involved in classified procurement. The Act clarifies that national security organs, e.g., military, intelligence agencies, are subject to the same general procurement principles as other public entities. However, they manage their procurement processes based on this dual list system to protect classified information. Procedures for classified procurement. The Act outlines specific procedures for classified procurements, emphasizing confidentiality and security. Limited disclosure. Information disclosed publicly is limited to what is necessary to maintain transparency without compromising national security. Restricted access. Access to classified procurement information is strictly limited to authorized personnel within the procuring entity and relevant oversight bodies. Cabinet approval for classified items. The Cabinet Secretary, responsible for finance, submits a list of classified items to the Cabinet for approval. This ensures high-level oversight and accountability for these sensitive procurements. Confidentiality obligations. All personnel involved in classified procurements are bound by strict confidentiality obligations. Disclosing sensitive information is an offense under the Act, carrying significant penalties. Safeguarding national security while maintaining transparency. The Act seeks to strike a balance between protecting national security and ensuring a level of transparency and accountability. While detailed information about classified procurements is not publicly available, the Act still requires procuring entities to provide general information about their procurement activities and awards. This approach seeks to maintain public trust while safeguarding national security. Part 8 underscores the importance of safeguarding national security while ensuring that procurement processes related to classified information are conducted with integrity and accountability. It recognizes the unique challenges posed by these procurements and provides a framework for balancing transparency with the imperative of protecting sensitive information. Part 9. Navigating the procurement maze. Part 9 of the Public Procurement and Asset Disposal Act outlines the various methods used to procure goods, works, and services by public entities in Kenya. This section provides a roadmap for navigating the procurement process, ensuring that the chosen method aligns with the specific needs of the procurement and adheres to the principles of fairness, transparency, and value for money. Open tendering. The default choice. The Act establishes open tendering as the preferred method for most procurements. This approach emphasizes open competition and allows any interested and eligible bidder to participate in the procurement process. Open tendering is generally considered the most transparent and competitive method, as it allows for a wider range of bids and promotes fair pricing. Alternative procurement methods. When open tendering isn't suitable. The Act recognizes that open tendering may not always be the most suitable approach. Part 9 outlines several alternative procurement methods, which can be utilized when certain conditions are met. 1. Two-stage tendering. Used for complex projects where detailed specifications cannot be determined upfront. The first stage involves soliciting proposals from bidders, and the second stage involves inviting detailed bids from shortlisted candidates. 2. Design competition. Employed for procuring creative services, such as architecture or engineering designs. This method encourages innovative solutions by inviting design proposals from multiple participants. 3. Restricted tendering. Applicable when competition is limited due to the specialized nature of the goods, works, or services being procured. This method involves inviting bids from a pre-selected group of qualified bidders. 4. Direct procurement. Used in specific circumstances where only one supplier can meet the procurement needs, such as procuring proprietary technology or in emergency situations. 5. Request for quotations. A simplified method used for procuring readily available goods, works, or non-consultancy services below a prescribed value threshold. This method involves requesting price quotations from multiple registered suppliers. 6. Electronic reverse auction. An online, real-time bidding process where suppliers compete by submitting progressively lower prices. This method encourages competitive pricing and can result in significant cost savings. 7. Low-value procurement. A streamlined process for procuring goods, works, or non-consultancy services below a specific value threshold. The specific procedures and conditions for using this method are outlined in the regulations. 8. Force account. Involves utilizing the resources of the procuring entity, such as its own personnel, equipment, and materials, to execute the procurement. This method is typically used for small-scale projects or in emergency situations where external procurement is not feasible. 9. Framework agreements. Allows procuring entities to establish long-term agreements with multiple suppliers for specific goods, works, or services. This method streamlines the procurement process for recurring needs and can lead to better pricing and contract terms. 10. Competitive negotiations. Applicable for procuring complex or specialized goods, works, and non-consultancy services where negotiations are necessary to finalize contract terms and pricing. 11. Request for proposals. Used for procuring consultancy services that are predominantly intellectual or advisory in nature. This method emphasizes the technical expertise and experience of the consultant rather than just the price. 12. Specially permitted procurement. Allows for the use of alternative procurement procedures in exceptional circumstances where the standard methods are not feasible or practical. The National Treasury must approve the use of these procedures. Choosing the right path. The selection of the appropriate procurement method is crucial to ensuring a successful procurement process. Factors to consider when choosing a method include the complexity and value of the procurement, the availability of qualified suppliers, the urgency of the procurement, the level of risk involved, pre-qualification, narrowing the field. For complex or specialized procurements, the Act allows for the use of pre-qualification procedures. This involves inviting potential bidders to demonstrate their qualifications and capabilities before submitting formal bids. Pre-qualification helps to ensure that only qualified and capable suppliers participate in the subsequent bidding process, ensuring a level playing field. Part 9 emphasizes the importance of fairness and transparency in the procurement process. Regardless of the method chosen, the Act mandates the use of clear and comprehensive tender documents, equitable evaluation criteria, and open communication with bidders. Part 9 provides a comprehensive framework for conducting public procurement in Kenya, offering a range of methods to suit different procurement needs while ensuring that the process remains fair, transparent, and accountable. By following the guidelines and procedures outlined in this section, procuring entities can achieve their procurement objectives effectively and efficiently. Part 10. Engaging expertise. Part 10 of the Kenyan Public Procurement and Asset Disposal Act focuses specifically on the procurement of consultancy services. Recognizing the unique nature of these services, which are primarily intellectual and advisory, the Act establishes tailored procedures for their acquisition. Defining the scope. When to use a request for proposals, RFP. Part 10 clarifies that an RFP is the appropriate method when the procurement involves services or a combination of goods and services, and the services being sought are advisory or predominantly intellectual in nature. This part of the Act allows for flexibility, permitting procuring entities to combine RFPs with other procurement methods outlined in Part 9, subject to any prescribed restrictions. This flexibility acknowledges the multifaceted nature of consultancy projects, which may require a blend of approaches. Setting the stage. Initiating the procurement process. The process for procuring consultancy services begins with the initiation phase, as outlined in Section 73 of the Act. However, Part 10 adds a specific requirement: the inclusion of expected milestones, performance benchmarks, and associated timelines within the terms of reference. This ensures clarity from the outset regarding the deliverables and expectations for the consultancy engagement. Casting a wide net. Inviting expressions of interest. Procuring entities have several options for inviting expressions of interest. They can advertise an RFP, seeking proposals from a broad pool of potential consultants. They can issue a notice inviting expressions of interest, allowing consultants to demonstrate their qualifications and experience. They can utilize the register of suppliers maintained by the procuring entity, which contains a list of pre-qualified consultants. Shortlisting and selection. Finding the right expertise. Following the submission of expressions of interest, an evaluation committee assesses the applications, using the criteria outlined in the notice and supporting documents. Based on this evaluation, the committee shortlists qualified candidates, documenting their rationale for both selecting and rejecting applicants. Only shortlisted candidates are invited to submit formal proposals. The Act emphasizes the need for fairness and transparency throughout the selection process. Procuring entities must simultaneously notify all tenderers in writing of the outcome of the expressions of interest phase. Defining expectations. Crafting a comprehensive request for proposals. The RFP package sent to shortlisted consultants includes a copy of the terms of reference and a detailed request for proposals. The RFP outlines essential information, including general and specific conditions of the contract, proposal submission procedures, evaluation criteria, emphasizing the importance of technical expertise and experience alongside price, provisions for contract negotiation. Alternative selection methods. The Act recognizes that a one-size-fits-all approach may not always be appropriate for selecting consultants. It outlines alternative selection methods, which can be employed under specific circumstances. Quality-based selection, QBS, focuses primarily on the quality of the consultant's proposal, with price playing a secondary role. Selection under a fixed budget. Used when the budget for the consultancy services is predetermined. List cost selection, LCS, employs a competitive bidding process, awarding the contract to the consultant with the lowest price that meets the minimum technical requirements. Single source selection permits the direct selection of a consultant without competition, but only under specific and justifiable circumstances. When using alternative selection methods, the procuring entity must prepare a report and submit it to the authority within 14 days. The authority provides written directions and guidelines to ensure proper reporting for these alternative methods. Ensuring value for money. Evaluating proposals. The Evaluation Committee examines submitted proposals using the procedures and criteria outlined in the RFP and the chosen selection method. The evaluation emphasizes both technical expertise and financial considerations. The committee's findings are documented in a report, providing a basis for the accounting officer's decision. Contractual clarity. Finalizing the agreement. Part 10 emphasizes the importance of a clear and comprehensive contract. The contract cannot deviate from the terms of reference, the RFP, or the successful proposal unless specific conditions are met. This ensures that both the procuring entity and the consultant have a shared understanding of their respective obligations and responsibilities. Part 10 of the Kenyan Public Procurement and Asset Disposal Act provides a detailed framework for procuring consultancy services, emphasizing fairness, transparency, and value for money. By adhering to these procedures, procuring entities can effectively engage skilled and qualified consultants, ensuring the successful delivery of essential advisory and intellectual services. Part 11. Sealing the deal. Understanding procurement contracts. Part 11 of the Kenyan Public Procurement and Asset Disposal Act focuses on procurement contracts, providing a framework for creating, managing, and amending these agreements. The Act emphasizes the importance of clear contractual terms, adherence to procurement procedures, and mechanisms for resolving disputes. Setting the foundation. Contract preparation and Attorney General review. The accounting officer of the procuring entity is responsible for preparing contracts in line with the award decision. For contracts valued at over 5 billion Kenyan shillings, an added layer of oversight is required. The Attorney General must clear these contracts before signing. This step ensures that high-value contracts are legally sound and protect the interests of the procuring entity. Additionally, each cabinet secretary must regularly update the cabinet and National Treasury about all government contracts exceeding 5 billion shillings. While this reporting requirement generally applies to contracts exceeding the 5 billion shilling threshold, the cabinet secretary may choose to brief the cabinet on any project deemed to be of national importance, regardless of its value. It's worth noting that this section does not apply to contracts entered into by Parliament and the judiciary. Formalizing the agreement. Creating a binding contract. The Act outlines a clear process for formalizing procurement contracts. The contract must be in writing and signed by both parties. This written contract, signed by the accounting officer or an authorized officer and the successful tenderer, becomes the official record of the agreement, incorporating all agreed-upon terms. The accounting officer is obligated to enter into a written contract with the successful tenderer, ensuring that the contract aligns with the tender documents and any subsequent clarifications arising from the procurement process. This step reinforces the principle of transparency and ensures that the contract accurately reflects the agreed-upon terms. Importantly, the contract must be signed within a specific timeframe. After a 14-day waiting period following the notification of award, but before the tender validity period expires. This timeframe strikes a balance between allowing sufficient time for review and ensuring that the contract is finalized within the tender's validity period. The Act also specifies the essential components that must be included in the written contract. Contract agreement form. Tender form. Price schedule or bills of quantities. Schedule of requirements. Technical specifications. General conditions of contract. Special conditions of contract. Notification of award. Failure to comply with the requirements for creating a written contract constitutes an offense under the Act. Consequences of refusal. Forfeiture of tender security. If the successful tenderer refuses to sign the written contract, they forfeit their tender security. This consequence incentivizes tenderers to honor their commitments and discourages frivolous bids. Following the forfeiture, the procurement process continues with the next lowest evaluated tenderer. However, this provision does not apply if the tender validity period has expired. Transparency and accountability. Publishing contract awards. To ensure transparency, the accounting officer is obligated to publish all contract awards. This publication must occur within a prescribed period and be displayed on the procuring entity's notice boards, website, and the government's advertising tenders portal. This public disclosure promotes accountability and allows for scrutiny of the procurement process. Managing contract changes. Amendments and variations. The Act recognizes that changes to a contract may be necessary during its execution. However, it establishes a structured process for managing amendments and variations. Any change to a contract resulting from a procurement process is only valid if the variation or amendment is approved in writing by the tender awarding authority within the procuring entity. The variation or amendment complies with the prescribed regulations for contract variations and amendments for goods, works, and services. The accounting officer, acting on the recommendation of an evaluation committee or as stipulated in the signed contract agreement, can approve requests for extension of the contract duration, price variations linked to fluctuating market conditions, quantity adjustments for goods, works, or services, modifications to the scope of work within the original contract's objective. It's important to note that the cumulative value of all contract variations for goods cannot exceed 25% of the original contract price. This safeguard prevents excessive contract inflation and ensures that variations remain within reasonable bounds. Addressing delays. Interest on overdue amounts and liquidated damages. The Act addresses the issue of delayed performance and overdue payments. The procuring entity is obligated to pay interest on overdue amounts owed to the contractor unless the contract specifies otherwise. Conversely, the contractor is liable for liquidated damages in case of delayed performance. Both the interest and liquidated damages are calculated according to the prevailing mean commercial lending rate determined by the Central Bank of Kenya. The specific methods for computing interest and liquidated damages are detailed in the regulations. Streamlining procurement. Framework contracting and multiple awards. To simplify procurement for recurring needs, the Act allows for framework contracting and multiple awards. Framework contracting involves establishing long-term agreements with multiple suppliers for specific goods, works, or services. This approach streamlines procurement, allowing procuring entities to access pre-negotiated terms and pricing for recurring requirements. Multiple awards involve awarding separate, partial contracts to two or more bidders for the same item. This strategy promotes competition and can secure more favorable pricing and terms. Securing performance. Performance security. To mitigate the risk of non-performance, the Act mandates the submission of performance security. The successful tenderer must submit this security, typically not exceeding 10% of the contract amount, before signing the contract. If the contract is not executed properly or fully, the procuring entity can unconditionally seize the performance security as compensation, in addition to any other penalties stipulated in the Act. However, tenders for consultancy services, works and supplies below a certain value threshold, and works and supplies reserved for disadvantaged groups may be exempt from this requirement or subject to a reduced performance security, not exceeding 1% of the contract price. The performance security typically takes the form of a bank guarantee or an insurance bond issued by a reputable bank or authorized financial institution. The issuing institution must be recognized by the Central Bank of Kenya. The Act establishes specific procedures for releasing the performance security. The procuring entity must release the security within 30 days of receiving a written application from the contractor, provided the contractor has fulfilled all contractual obligations. For procurement of works, this 30-day period begins from the date of practical completion or handover, whichever occurs first. Managing payments. Advance payments and retention. The Act allows for advance payments under exceptional circumstances, but these payments cannot exceed 20% of the tender price. The successful tenderer must provide advance payment security equivalent to the advance amount before receiving the payment. This security ensures that the advance payment is used solely for activities related to the tender. If the tenderer diverts any portion of the advance payment to unrelated activities, the full amount becomes immediately due as a debt, and the procuring entity can seize the security as repayment. Managing subcontracting. Ensuring compliance and eligibility. The Act allows for subcontracting under specific conditions. If the tender documents do not explicitly prohibit subcontracting, the successful tenderer can subcontract a portion of the work. However, the subcontractor must not be debarred from participating in procurement proceedings under the Act and must not have been involved in the procurement of goods, works, or services related to the contract being subcontracted. Ensuring quality. Contract administration and acceptance. The Act emphasizes the importance of effective contract administration to ensure that the procured goods, works, or services meet the required quality and quantity standards. The accounting officer of the procuring entity plays a key role in this process, verifying that deliverables align with contractual specifications. For technical goods, works, and services, the responsibility for confirming quality and quantity might rest with a technical department or professionals engaged by the accounting officer. Upon acceptance, a certificate of acceptance is issued to the accounting officer. Safeguarding public resources. Preventing asset disposal to employees. To prevent conflicts of interest and protect public assets, the Act prohibits the disposal of assets to employees or board/committee members of the procuring entity, except under specific conditions outlined in the Act and regulations. This provision safeguards public resources and prevents the misuse of insider information for personal gain. Part 11 of the Kenyan Public Procurement and Asset Disposal Act provides a comprehensive framework for managing procurement contracts. The Act emphasizes transparency, accountability, and fairness throughout the contract lifecycle, from preparation to administration and amendment. By adhering to the procedures and regulations outlined in this section, procuring entities can ensure the efficient and effective use of public funds and the acquisition of high-quality goods, works, and services. Part 12. Empowering local industry. Understanding preferences and reservations. Part 12 of the Kenyan Public Procurement and Asset Disposal Act focuses on preferences and reservations in procurement, aiming to bolster Kenyan industries and support disadvantaged groups. This part of the Act mandates that procuring entities prioritize Kenyan goods and services while also allocating a portion of their procurement budget to empower specific groups, including youth, women, and persons with disabilities. Supporting local products and businesses. Prioritizing Kenyan goods and services. The Act prioritizes the procurement of goods, works, and services originating from Kenya. This preference applies to items wholly mined or produced in Kenya, as well as to those partially mined or produced in Kenya or assembled in Kenya. The emphasis on local procurement aims to stimulate Kenyan industries and create employment opportunities within the country. The Act also extends preferences to firms where Kenyans hold a majority shareholding over 51%. This provision encourages foreign companies to partner with Kenyan businesses, fostering the transfer of skills and technology. Empowering disadvantaged groups. Reservations and quotas for inclusivity. Beyond promoting local industries, Part 12 introduces reservation schemes designed to support disadvantaged groups. Procuring entities are obligated to reserve a minimum of 30% of their procurement budget for these groups, encompassing youth, women, persons with disabilities. To ensure accountability, procuring entities must report their compliance with these reservation schemes to the authority every 6 months, providing data disaggregated by the number of youth, women, and persons with disabilities whose goods and services were procured. Ensuring accessibility and transparency. Facilitating participation and monitoring compliance. To participate in these preference and reservation schemes, candidates must provide evidence of their eligibility, as outlined in the regulations. This requirement ensures that only qualified individuals and businesses benefit from these provisions. The Act establishes a Preference and Reservations Secretariat within the National Treasury to oversee the implementation of these schemes. This secretariat is responsible for registering, pre-qualifying, and certifying eligible individuals and businesses, providing training and capacity building for target groups, offering technical and advisory assistance to procuring entities, monitoring and evaluating the implementation of these schemes, reporting to the National Treasury. To ensure transparency, procuring entities must report all procurement awards where preference or reservation schemes were applied to the authority on a quarterly basis. These reports must include disaggregated data to demonstrate the impact of these initiatives. Promoting local content in international tenders. Encouraging citizen contractor participation. Recognizing the importance of local participation even in international tenders, the Act encourages foreign tenderers to source at least 40% of their supplies from citizen contractors. This provision aims to leverage international contracts to benefit local businesses and stimulate economic growth. Part 12 of the Kenyan Public Procurement and Asset Disposal Act demonstrates a commitment to promoting local industries and supporting disadvantaged groups. By prioritizing Kenyan goods and services and implementing reservation schemes, the Act aims to foster inclusive economic growth, empower marginalized communities, and enhance the overall well-being of Kenyan citizens. Part 13. Managing Public Assets. Part 13 of the Public Procurement and Asset Disposal Act focuses on inventory control, asset and stores management, and distribution, providing guidelines for managing public assets effectively. This part outlines the responsibilities of accounting officers in receiving and recording goods and services and emphasizes the importance of efficient inventory control, asset management, and distribution systems. Receiving and recording goods, works, and services. Establishing accountability. Section 159 of the Act underscores the importance of accountability in the receipt and recording of goods, works, and services by procuring entities. It mandates that accounting officers only accept items that have been properly certified, ensuring that they align with the agreed-upon quality and quantity. Technical certifications. When dealing with technical goods, works, or services, a technical department or designated professionals must provide a certificate to the accounting officer confirming the quality and quantity of the items delivered. Certificate of acceptance. The person responsible for receiving goods, works, or services must inspect them to ensure compliance with the contract and issue a certificate of acceptance to the accounting officer. Objectives of inventory control, asset and stores management and distribution. Optimizing value and meeting objectives. Section 160 outlines the key objectives of inventory control, asset management, and distribution, emphasizing the creation of value and the alignment to the procuring entity's goals. These objectives include efficient use of public resources, establishing and maintaining optimal stock levels to prevent overstocking or shortages, safeguarding public assets, implementing systems to secure assets from loss, damage, or theft, maximizing asset lifespan, ensuring proper maintenance and care of assets to extend their useful life, effective distribution, establishing mechanisms for the timely and efficient distribution of goods, ensuring they reach their intended beneficiaries, transparency and accountability, maintaining accurate records of all inventory, assets, and distribution activities. Guidance from the authority. Manuals and guidelines for effective asset management. To facilitate the effective implementation of these objectives, the authority is tasked with issuing manuals and guidelines covering all aspects of inventory, stores, and asset management. These resources provide practical guidance to procuring entities, enabling them to develop robust asset management systems tailored to their specific needs. Part 14. Disposing of public assets. Part 14 of the Public Procurement and Asset Disposal Act outlines the procedures for disposing of public assets, complementing Part 13's focus on asset management. It emphasizes transparency, accountability, and fairness in the disposal process, aiming to ensure that public assets are handled responsibly and generate optimal value for the Kenyan people. Establishing a disposal committee. Expertise and oversight in asset disposal. Similar to the evaluation committees discussed in our conversation about Part 12, Part 14 mandates the establishment of a disposal committee by the accounting officer. This committee plays a crucial role in overseeing the disposal of unserviceable, obsolete, or surplus assets. Its responsibilities include verifying and processing disposal recommendations received from various departments, ensuring that only assets meeting the criteria for disposal are considered. Working in close collaboration with the head of the procurement function to ensure compliance with the Act and regulations. Initiating the disposal process. Transparency and timeliness. The process for disposing of assets begins when the employee responsible for the assets identifies them as unserviceable, obsolete, or surplus. This employee must promptly notify the disposal committee through the head of the procurement function. This requirement ensures that assets are not unnecessarily held and that the disposal process is initiated in a timely manner. Determining the best disposal method. Technical expertise and market analysis. Once notified, the disposal committee undertakes a comprehensive assessment of the assets, considering the following factors. Technical condition. A relevant technical expert prepares a report evaluating the asset's condition and their potential for repair or refurbishment. Market value. The technical expert also determines the asset's real market price, setting a reserve price, the minimum acceptable price below which the assets cannot be sold. Disposal methods. The committee recommends the most suitable method for disposing of the assets, such as transfer to another public entity, public tender, public auction, trade-in, or waste disposal management. This multifaceted approach ensures that the disposal method selected maximizes the value derived from the assets while adhering to the principles of transparency and fairness. Transparency and disclosure. Ensuring fairness in the disposal process. To promote transparency and fairness in the disposal process, the accounting officer must disclose the reserve price to all prospective bidders. This disclosure allows bidders to make informed decisions and ensures that the bidding process is competitive and transparent. If no bids meet the reserve price, the accounting officer, based on the disposal committee's recommendations, can revise the reserve price to facilitate the disposal of the assets. This provision prevents unnecessary delays in disposing of assets while maintaining accountability and transparency by documenting the revised price in the disposal documents. Disposal of hazardous materials. Protecting the environment and public health. Part 14 also addresses the disposal of hazardous materials such as radioactive or electronic waste. It mandates that these materials be disposed of only to entities licensed under the Environmental Management and Coordination Act. This requirement ensures that the disposal process adheres to environmental regulations and protects public health. Preventing conflicts of interest. Restricting disposal to employees and board members. To prevent conflicts of interest, the Act prohibits the disposal of assets to employees or board members of the procuring entity, except in specific circumstances permitted by the Act and regulations. This provision safeguards against favoritism and ensures that public assets are disposed of in the best interests of the public. Part 14 of the Public Procurement and Asset Disposal Act provides a comprehensive framework for the disposal of public assets. By emphasizing transparency, accountability, and fairness throughout the process, the Act aims to ensure the responsible management of public resources and their optimal utilization for the benefit of Kenyan citizens. Part 15. Resolving disputes. Understanding administrative review. Part 15 of the Kenyan Public Procurement and Asset Disposal Act focuses on administrative review, providing a mechanism for resolving disputes that may arise during procurement and asset disposal proceedings. This part outlines the process for requesting a review, the powers of the review board, and the rights of parties involved in a dispute. Requesting a review. Seeking redress for breaches of duty. Section 167 of the Act grants candidates or tenderers the right to seek administrative review if they believe a procuring entity has breached its duties as defined by the Act or its associated regulations. This review process aims to provide a fair and impartial platform for addressing grievances and ensuring that procurement and disposal proceedings are conducted in accordance with the law. To initiate a review, the aggrieved party must submit a request within 14 days of either notification of award, if the dispute concerns the awarding of a contract, date of occurrence, if the dispute pertains to an alleged breach at any other stage of the procurement or disposal process. The request must clearly outline the grounds for the review and be accompanied by a refundable deposit, which serves as a deterrent against frivolous claims. The deposit amount is typically set at 10% of the contract value. However, this requirement is waived for tenders reserved for women, youth, persons with disabilities, and other disadvantaged groups, ensuring that these groups have equal access to the review process. Powers of the Review Board. Resolving disputes and ensuring compliance. The Public Procurement Administrative Review Board, established under Part 2 of the Act, is responsible for adjudicating administrative reviews. The board has the authority to investigate the matter, examining the evidence presented by both parties to determine if a breach of duty has occurred, issue orders, directing the procuring entity to take corrective actions, such as amending the procurement process or re-evaluating tenders. Annul decisions. Cancelling decisions made by the procuring entity if they are found to be unlawful or in violation of the Act. Award compensation. Ordering the procuring entity to compensate the aggrieved party for losses suffered due to a breach of duty. Allocate costs. Determining which party should bear the costs associated with the review process. Transparency and fairness. Open hearings and additional rights. To ensure transparency and fairness, the Act mandates that reviews be conducted in an open forum, allowing for public scrutiny of the process. However, exceptions can be made in cases where national security or the integrity of the review procedure might be compromised. It's important to note that the right to administrative review is in addition to any other legal remedies available to aggrieved parties. If dissatisfied with the review board's decision, parties can seek judicial review by the High Court within 14 days. Exclusions from review. Matters outside the board's jurisdiction. While the review board has broad powers to address procurement disputes, the Act outlines certain matters that are not subject to review, including choice of procurement method. The Act grants procuring entities the discretion to select the most appropriate procurement method based on their specific needs and circumstances. This decision is not subject to administrative review. Termination of procurement proceedings. If a procuring entity terminates procurement proceedings in accordance with the Act, this decision generally cannot be challenged through administrative review. Contract signing. Once a contract has been signed in compliance with the Act, disputes relating to the procurement process leading up to the contract are generally not subject to review. Part 15 of the Kenyan Public Procurement and Asset Disposal Act provides a robust framework for resolving procurement disputes. By establishing an independent review board with the power to investigate and adjudicate complaints, the Act aims to ensure that procurement and disposal proceedings are conducted fairly, transparently, and in accordance with the law. This mechanism not only protects the rights of bidders and tenderers but also enhances the integrity and accountability of the public procurement system as a whole. Part 16. Upholding ethical conduct. Understanding offenses and sanctions. Part 16 of the Public Procurement and Asset Disposal Act focuses on upholding the integrity and accountability of the public procurement system by outlining prohibited actions, offenses, and associated penalties. This section ensures that all parties involved in procurement and asset disposal proceedings adhere to ethical and legal standards. Prohibited actions. Safeguarding transparency and fairness in procurement. Section 176 of the Act lists specific actions that are strictly prohibited, aiming to prevent misconduct and maintain a level playing field for all participants. These prohibited actions cover a wide range of activities, including obstructing or hindering investigations, impeding authorized individuals from carrying out their duties under the Act, providing false or misleading information, knowingly lying to or misleading those conducting investigations or performing their functions, delaying procurement processes, unjustifiably delaying activities like tender opening, evaluation, contract awarding, or contractor payments, divulging confidential information, disclosing sensitive information protected under Section 67 of the Act, which pertains to confidentiality in procurement. Exerting inappropriate influence. Attempting to influence the evaluation of tenders or other aspects of the procurement process. Splitting contracts. Structuring procurement in a way that avoids the required procedures, as discussed in Section 54. Engaging in fraudulent practices. Participating in any deceptive or dishonest activities during the procurement process. Withholding notifications. Intentionally failing to inform successful and unsuccessful tenderers about the outcome of the procurement process. Signing contracts unlawfully. Entering into contracts that violate the requirements of the Act or its associated regulations. Disobeying lawful orders. Failing to comply with directives issued by the authority under Part 4 or the Review Board under Part 15. Consequences of prohibited actions. Penalties and debarment. Engaging in any of the prohibited actions constitutes an offense under the Act, leading to severe consequences for both individuals and corporations. Individuals found guilty of an offense face fines up to 4 million Kenyan shillings, imprisonment up to 10 years, both fine and imprisonment, depending on the severity of the offense. Corporations found guilty face fines of up to 10 million Kenyan shillings. In addition to these penalties, state or public officers will be subject to internal disciplinary action. Other individuals involved in the offense may be debarred, preventing them from participating in future procurement activities. Professional accountability. Complaints to regulatory bodies. The Act further empowers the authority to lodge complaints with relevant professional bodies against members who violate the Act's provisions during procurement proceedings. This mechanism ensures that professionals involved in procurement are held accountable to their respective codes of conduct and ethical standards. Penalties imposed by professional bodies apply in addition to any penalties imposed under the Act, highlighting the seriousness with which unethical conduct is treated in the context of public procurement. Protection from personal liability. Acting in good faith. While the Act emphasizes accountability, it also provides protection from personal liability for individuals who act in good faith while performing their duties under the Act. This provision ensures that individuals are not unfairly penalized for making genuine errors or acting on decisions made in good faith. Indemnity for employees and board members. Legal protection for official duties. The Act also mandates that procuring entities indemnify their employees and board members who face legal proceedings, civil, criminal, or administrative, arising from their official actions during procurement or asset disposal processes. However, this indemnity is subject to certain conditions. The employee or board member must have engaged private legal counsel, demonstrating their commitment to defending themselves against the allegations. They must not have been found guilty of gross negligence, misconduct, or abuse of office, ensuring that indemnity only applies to those acting responsibly and ethically. Part 16 of the Public Procurement and Asset Disposal Act establishes a clear framework for addressing offenses and enforcing ethical conduct in public procurement. By outlining prohibited actions, establishing penalties, and providing mechanisms for accountability, the Act aims to deter misconduct, protect public resources, and maintain the integrity of the procurement system in Kenya. Part 17. Promoting collaboration and transparency in public procurement. Part 17 of the Public Procurement and Asset Disposal Act outlines the mechanisms for operationalizing and reviewing public procurement policy in Kenya. This part emphasizes collaboration between stakeholders, continuous improvement of the procurement system, and the development of ethical guidelines. Consultative meetings. Facilitating dialogue and feedback. Section 179 mandates that the National Treasury convene annual meetings to consult with individuals and organizations from both the public and private sectors who have a stake in the effective functioning of the public procurement system. This collaborative approach aims to gather diverse perspectives, address concerns, and identify areas for improvement. While the sources do not specify the exact procedures for conducting these meetings, they highlight the importance of regular and inclusive consultations to ensure that procurement policies are responsive to the needs and challenges faced by various stakeholders. Regulations. Providing detailed guidance and parliamentary oversight. The Act grants the Cabinet Secretary the authority to formulate regulations that provide detailed guidance on implementing the Act's provisions. This ensures clarity and consistency in the application of procurement rules across different entities. Importantly, these regulations must undergo parliamentary approval, ensuring democratic oversight and accountability in shaping procurement policies. This emphasis on regulations underscores the Act's commitment to providing a comprehensive and adaptable framework for public procurement, recognizing that specific procedures and requirements may need to evolve over time to address emerging challenges and best practices. Code of Ethics. Establishing ethical standards for all participants. To promote ethical conduct and prevent misconduct, Section 181 mandates that the authority develop a code of ethics applicable to all individuals and organizations involved in public procurement and asset disposal processes. This code serves as a guide for ethical decision-making and sets clear expectations for behavior. By establishing a code of ethics, the Act underscores the importance of integrity, transparency, and accountability in all aspects of public procurement. This proactive approach aims to foster a culture of ethical conduct, promoting fair competition, and protecting public resources. Part 17 of the Public Procurement and Asset Disposal Act establishes a foundation for continuous improvement in the public procurement system. By encouraging dialogue, establishing clear procedures, and promoting ethical conduct, this part aims to enhance the efficiency, transparency, and accountability of public procurement in Kenya. Part 18. Transitioning to a new procurement era. Part 18, titled A Repeal, Transition, and Savings Provisions, focuses on the legal mechanics of implementing the Public Procurement and Asset Disposal Act and ensuring a smooth transition from previous legislation. While the specific content of this section has been superseded, marked as spent in sources, its purpose is essential to understanding the broader legal context of the Act. Repeal of existing legislation. Making way for a new procurement framework. Part 18 would have initially included provisions for repealing existing laws related to public procurement, paving the way for the new Act to take effect. This signifies a clear intention to establish a comprehensive and unified legal framework for procurement in Kenya, replacing potentially outdated or fragmented legislation. Transition provisions. Ensuring continuity during implementation. This part would have likely outlined procedures for managing the transition from the old legal framework to the new Act. These provisions could have included timelines, specifying dates for different aspects of the Act to come into force, transfer of responsibilities, outlining how functions and powers would be shifted to the newly established institutions like the Authority and the Review Board, handling existing contracts, establishing procedures for managing procurement contracts that were initiated under previous legislation. Alignment of existing practices. Providing guidance on how procurement entities should adapt their internal processes to comply with the new Act. Savings provisions. Protecting existing rights and obligations. Part 18 may have also contained savings provisions to ensure that certain rights, obligations, or legal proceedings initiated under the previous legislation were not affected by the Act's implementation. This would have ensured legal continuity and prevented disruption during the transition. Significance of transition and savings provisions. While the specific details of Part 18 are no longer applicable, the concept of transition and savings provisions is crucial in any significant legal reform. These provisions are designed to minimize disruption, ensure a smooth and orderly shift to the new legal regime, protect legitimate expectations, safeguard the rights and obligations of parties involved in ongoing procurement processes, prevent legal uncertainty, provide clarity on the applicability of the new law and its interaction with existing legal frameworks. Though marked as spent, Part 18's purpose highlights the importance of carefully managing legal transitions, ensuring a stable and predictable environment for public procurement even as laws evolve. Understanding schedules in legal documents. A simplified explanation. Schedules are supplementary documents attached to a main legal document, like an act or a contract. They provide detailed information that expands upon or clarifies specific aspects of the main document without cluttering its primary text. Think of schedules as appendices or annexes that offer additional details or instructions related to the main document. Purpose of schedules: keeping main documents concise and organized. Using schedules allows the drafters of a legal document to maintain clarity and conciseness. By moving specific details to schedules, the main document remains focused on core principles and provisions. Enhance readability. Schedules prevent the main text from becoming overly complex or difficult to follow, making it more accessible to a wider audience. Provide flexibility. Schedules can be easily amended or updated without requiring modifications to the main document. Organize complex information. Schedules allow for the systematic presentation of detailed information, making it easier to locate and understand. Examples of schedules. Illustrating their role in the Procurement Act. The sources you provided, specifically the Public Procurement and Asset Disposal Act of Kenya, include 3 schedules. 1. First Schedule, S14-1. This schedule, titled Provisions Relating to the Conduct of Business and Affairs of the Board, outlines the procedures for the Public Procurement Regulatory Board. It covers aspects like frequency and convening of meetings, notice requirements for meetings, decision-making processes, including voting procedures, role of the Secretary and maintenance of minutes. 2. Second Schedule, S31. This schedule, titled Provisions Relating to the Conduct of Business and Affairs of the Review Board, establishes the procedures for the Public Procurement Administrative Review Board. It mirrors the first schedule in terms of content, outlining procedures for meetings, voting, and record keeping. 3. Third Schedule, S183. This schedule, titled Transitional Provisions, was intended to facilitate the smooth implementation of the Act. However, it is currently marked as spent, meaning its provisions are no longer in effect. Key takeaways. Understanding the significance of schedules. Schedules provide essential details that support the main provisions of a legal document. They help organize information, making the document more user-friendly. Schedules can be easily amended without altering the main document. By referring to the schedules, you gain a deeper understanding of the specific procedures and requirements outlined in the main Act.